Chief Justice. I'll try to be as brief
I was
and...
going to say, is there much to say from your point of view that we haven't already heard?
For most people, perhaps not, Justice Greene, but
Oh, okay.
I will try to be brief.
Wait to
and,
be enlightened then, thank you.
I think that David Hirsch, first of all, representing Mr. Andrews in this case, I think Justice Spina hit the nail on the head when he pointed out that Bridgewater State Hospital wears two separate hats. In cases such as Kansas versus Hendricks, in this court, Bruno, Hill, Dutil, this court, as well as the U.S. Supreme Court, have always made such a point making it clear that this kind of commitment, that any kind of civil commitment, of truly civil commitment, must be distinguished from criminal proceedings, from any kind of punitive proceedings. Over and over, this court has pointed out that 123A is constitutional because it is not punitive. But if we were to accept my sister's argument concerning the nature of Bridgewater State Hospital, if everybody there, whether committed under Section 18 or Section 8 of Chapter 123A, of Chapter 123, is a prisoner, then not only 123A, but 123 commitment to Bridgewater would be open to severe and major constitutional challenge on grounds that it is punitive.
Well, that's just in the meaning of prisoner. That's just a definitional word. Just because you call someone in a state hospital, let's assume the statute defined a prisoner, someone confined in a state hospital, or confined under a committed sentence, or this or that. Isn't that just definitional? That doesn't change necessarily the conditions of their confinement.
No, Your Honor, I think, well, it doesn't change the conditions. It changes the nature of the confinement.
Just because you call them prisoners versus
Absolutely.
patients?
I would say so. If a prisoner is not again, we're bound by common usage as...
Well, no, we have a statute that defines prisoner for purposes of certain statutes.
Yes, we have and as Justice Spina pointed out, that definition of prisoner can constitutionally only apply to those who are committed to Bridgewater State under Section 18, not to those who are committed under Section 8.
Stated differently, I assume that if the legislature is saying these are prisoners, the legislature may be recognizing a reality that, in fact, it is punitive. Correct?
For those who are held under Section 18, you mean?
Yes.
Yes, I would agree. Several other points. One, what is the standard by which this court construes the language of this statute? My brother, Mr. Day, pointed out McLeod. I have pointed out in my brief an older case from 1904, Commonwealth versus Beck. Laws in derogation of the liberty or general rights of the citizen are to be strictly construed. I believe that remains and must remain the law of this state. The next point, Your Honor, the meaning of confinement. Here I think that Justice Sussman pointed the way here. My approach in my brief to the meaning of the term confinement was, I believe, overly flippant, and I apologize to the court and to my sister for that. And I think Justice Sussman's resolution of the issue is a far wiser one. Confined is not superfluous. It refers to various people, such as persons on probation and parole holds who have not yet been found in violation, to people who are in jail awaiting trial. I believe that these people are subject, under current law, to under amended Section 12A of 123A to commitment. They are confined. People, as Justice Sussman pointed out, who are being held as incompetents are confined. The statute, the meaning of any term in a statute can be gleaned from the context of the statute as a whole, as this court said this year in Commonwealth Insurance Company versus Commissioner of Insurance. That, I think, is how we have to glean it here, given the emphasis in the statute on prisoners or youths in the custody of DYS. The court asked whether Shedlock created any problems for the defense point here. I don't think so, because I think Mr. Day pointed this out. In case he didn't, I will repeat it. This is an issue of the Commonwealth's own making. This is not an issue where the Commonwealth could not act as in Shedlock because the individual could not be released for several more years until he finished his sentence. The Commonwealth had every power within that 6-month period to decide, rather than go for a Section 8, we're going to go for a 123A commitment. They chose. Now, in Shedlock, the court decided that, as it did, because it wanted to avoid waste and duplication. The only waste and duplication in a case such as this would be allowing the Commonwealth to change its mind at this time, to decide first we're going to go under Section 8, under 123, and then we're going to change our minds and do 123A. Secondly, I think the Commonwealth is, my sister has created a straw man here. The Commonwealth quotes Shedlock, "The frustration of the legislative objections animating 123A, public protection and rehabilitative treatment that would result from construing release as the respondent desires compels an interpretation that makes the operation of the statute meaningful. But if Mr. Andrews is to be released from his commitment under 123 Section 8, it could only be because he's either no longer mentally ill or no longer dangerous. And therefore, there would be no basis for his commitment under any statute." The court in, well, if I'll try to hurry up as quickly as I can here. If he could not be committed under 123 Section 8, and then the Commonwealth sought commitment under 123A, there would be a major equal protection problem, because then the Commonwealth, in essence, would be admitting we're going to go after him under the statute which allows a more lenient standard of commitment. And that's precisely what Jackson versus Indiana says that a state government cannot do, cannot discriminate among people facing commitment by creating a more stringent basis for commitment and a more lenient basis for commitment and a more stringent basis for release for one category based upon another, based upon their choice of statutes. That's exactly what the Commonwealth is asking for power to do here. Finally, my sister argues that the Commonwealth is often not given enough notice, and that's certainly a problem. If the court would like, I can provide a very long list of cases in which the Commonwealth filed its petition within 7 days of the expiration of the person's criminal sentence. But that is a problem for the executive. Something's broken. They have to fix it. This court found 123A constitutional in Bruno partially upon the assurance of the Commonwealth that most, if not all, of the proceedings in a 123A trial could be completed within that 6-month notice period. This court repeated those claims as a partial basis for its decisions in both Knapp and Kennedy. If, at this point, that's no longer possible, I think we'd be in the very difficult position of having to reassess Bruno as a whole. Other than questions from the court, I'm done.
Thank you, Mr. Hirsch.
Thank you, Your Honor.